Hello. Constitution and its making. Constitution. The Constitution is the compact document that comprises a number of articles about a state, specifying how the state is to be constituted and what norms it should follow. It is the fundamental law and law of the land function. It, it provides a set of the basic rules that allow for the minimal coordination among the members of society. It specifies who has the power to make the decision in the society. It decides how the government will be to constitute, uh, to set up the some limits what a government can impose on its citizen. The government may never trespass these limits to enable the government to fulfill the aspiration of the society and create the condition for a just a society. The constitution expresses the fundamental unity of a people, constitutionalism and the constitutional morality. The constitutionalism refers to a system of governance when where a constitution limits the government power and ensure the rule of law, prevailing the arbitrary authority and the protecting the individual rights. This approach requires the democratic governance, where the power is distributed evenly on the single individual institution holds absolute control. Constitutional morality means adherence to the core of principle of the constitution is in a democracy. Example, a moral obligation of individual to uphold the constitutional values with the almost dignity without any compromise and being faithfully towards it. A state. A state in a political science that has four features. A fixed territory. Second, the sovereignty, no external control. Third, population. Fourth, government. A state is similar to the word country, whereas the word state is used for the constituent unit such as Uttar Pradesh, Bihar, etc. A nation is a large group of people who inhabit a specific territory and the connected by the history, culture, or any other communality. A nation state is a state having above the mentioned four features. First, a fixed territory. Second, sovereignty. Third, population. Fourth, government features, where people are connected to each other by history, culture, language, etc. British have raised the question on the land India being a nation because of divided loyalties and lacking of the common identity. However, the extremists like the Aurobindo have established India as a nation through a cultural nationalism. Even today, some scholars believe that the India is a nation in making. Overview of the Indian Constitution. Schedule. Subject parts of article, subject part and the article. The Union and Territory. Part 1. Article 1 to 4. Citizenship. Part 2. Article 5 to 11. Fundamental Rights. Part 3. Article 12 to 35. DPSP. Part 4. Article 36 to 51. Fundamental Duty. Part 4A. Article 51A. Union. Part 5. Article 52 to 151. Chapter 1. The Executive. Article 52 to 78. Chapter 2. Parliament. Article 79 to 122. Chapter 3. Legislative power of the President, Article 123. Chapter 4, the Union Judiciary, Article 124 to 147. Chapter 5, CAG, Article 148 to 151. The State, Part 6, Article 152 to 237. Chapter 1, Journal, Article 152. Chapter 2, the Executive, Article 153 to 167. Chapter 3, the State Legislature, Article 168 to 212. Chapter 4, the Legislative Power of the Governor, Article 213. Chapter 5, the High Courts, Article 214 to 232. Chapter 6, the Subordinate Court, Article 233 to 237. The Finance, Property, Contract and the Suits, and the Chapter 1, the Finance, Article 12 and Article Part 12, Article 264 to 301, Article 264 to 291. Chapter 2, the Borrowing, Article 292 to 293. State in the Part B of the first schedule, Part 7, repealed by the 7th Constitutional Amendment Act 1956. The Union Territory, Part 8, the Article 238 to 242. The Panchayat, Part 9, Article 243 to 243O. The Municipalities, Part 9A, the Article 243P to 243ZG. Cooperative Society, Part 9B, the Article 243H to 243ZT. The Schedule and the Tribal Areas, the Part 10, the Article 244 to 244A. Relationship between the Union and State, Part 11, Article 245 to 263. Chapter 1, the Legislative Relation, Article 245 to 255. Chapter 2, Administrative Relationship, Article 256 to 263. Official Language, Part 17, Article 343 to 351. The Chapter 1, the Language of the Union, Article 343 to 344. Chapter 2, the Regional, the Article 345 to 347. Chapter 3, the Property, Contract, Right and the Liabilities, Obligation and the Suits, Article 294 to 300. Chapter 4, Right to the Property, Article 300A. Trade, Commerce and the Intercourse within the Treaty of India. Part 13, Article 301 to 307. Services under the Union and the State. Part 14, Article 300 to 8, 300 to 23. The Tribunals. Part 14A, Article 323A. Election, Part 15, Article 324 to 329. Special provisions relationship to the certain classes. Part 16, Article 330 to 342. Language, Chapter 3, Language of the Supreme Court and High Court and so on. Article 348 to 349. Chapter 6, 4, Special directives, the Article 350 to 351, the emergency provisions, Part 18 to 18, Article 353 to 360, the miscellaneous, Part 19, Article 361 to 367, the amendment of the Constitution, Part 20, Article 368, the temporary, transitional, and special provisions, Article Part Part 21, Article 369 to 360 and 92, a short title, commencement and the authority next text in the Hindi and the repeals, Part 22, Article 393 to 395. Schedule feature. Schedule 1, name of the state and union territory and their the territorial judiciary. Schedule 2, the allowance, privileges and emolument of the President of India, governors of Indian state, Speaker of the Lok Sabha and Deputy Speaker of the Lok Sabha, Chairman of Rajya Sabha, Deputy Chairman of the Rajya Sabha, Speaker and Deputy Speaker of Legislative Assembly of Indian State, the Chairman and Deputy Chairman of the Legislative Council of the Indian State, Supreme Court Judges and High Court Judges and CAG. Schedule 3, the oath or affirmation for Parliament election candidates, MPs, Union Ministers of India, State Legislature election candidates, MLAs, State Ministers, Supreme Court Judges, High Court Judges, CAG. Schedule 4, the allocation of the seat for the state and union territory in the Rajya Sabha. Schedule 5, the administration and control of the scheduled area and the scheduled tribe. Schedule 6, the administration of the tribal area in Assam, Meghalaya, Tripura and Mizoram. Schedule 7, list of union, state and concurrent. Schedule 8, the contain the 22 official language recognized by the Constitution of India, referred below table. Schedule 9, added by the First Constitutional Amendment Act 1951, provisions so as the validation of the certain acts and the regulation. The Parliament can replace any law in this schedule. The earlier mostly and the Reform Act were the place in this schedule and the prevent reform and being a challenge in Supreme Court grounds of the violation of the fundamental rights to property, but later other acts were also placed the prevalent judicial security. However, Supreme Court in IR coherence case held that any law in this schedule can be judicially reviewed on the grounds of the violation of basic structure introduced during the prime ministership of the Jawaharlal Nehru. Schedule 10, anti-defection law provisions. Added by the 52 Constitutional Amendment Act 1985. 11. Schedule 11, added by the 73rd Constitutional Amendment Act 1992. Powers, authority and responsibility of the Panchayats. The Schedule 12, added by the 74th Constitutional Amendment Act 1992. Power, authority and responsibility of the municipalities. 18 matters. 14 language in the original constitution: Assami, Bengali, Gujarati, Hindi, Kashmiri, Tamil, Telugu, Malayalam, Kannada, Marathi, Odia, Punjabi, Sanskrit, Urdu. Added by the 21st Constitutional Amendment Act 1967, Sindhi. added by the 71st Constitutional Amendment Act 1992, Konkoni, Manipuri, Nepali, added by the 92nd Constitutional Amendment Act 2003, Bodo, Dogri, Maithili, Santhali, 96th Constitutional Amendment Act 2011, Odia is a change in Odia. Feature of the Indian Constitution. First, lengthiest written constitution, presently about the 465 article divided into 25 parts and the 12 schedules. Originally 396 article, 22 parts, 8 schedule. Second, parliamentary form of government. The presence of the nominal and the real executives. Majority party rule. The collective responsibility of the executive to the legislature. Dual membership of ministers. Leadership of the prime ministers. The devolution of the lower house, Lok Sabha or the assembly. 3. Integrated and the independent judiciary. The fourth, synthesis of the parliamentary sovereignty and judicial supremacy. Synthesis between the British parliamentary sovereignty and the American judiciary supremacy. The blend of the rigidity and the flexibility. Living documents. Fifth, the federal feature of the Union treaty biases. Unitary biases. The no strict Sixth, no strict separation of power, but the checks and the balances are present. Time Timeline of the Constituent Assembly. 1934, at the idea of M.N. Roy. 1935, first demand of the Constituent Assembly by the Congress. 1940, the in principle acceptance by the August offer. 1942, draft proposal by the Cripps Mission. 1946, the election of the Constituent Assembly based on the Cabinet Mission. The Constituent Assembly was the party elected and party nominated. The member were the indirectly elected by the member of the Provincial Assembly who themselves were elected on the limited finances franchises. Originally 389 seats and the 296 for provinces. Congress on the 209 and the 93 are the princely estate. Later, after the independence of Indian Act, the seats reduced to 299 and for the provinces it because 229 for and for the princely estates 70 seats in the each provinces were the distributed among the three main communities Muslim, Sikhs and general not Hindu. 9 December 1946, first meeting Muslim leagues boycotted. Sachitananda Sinha was the provincial president. 11 December 1946, Rajendra Prasad elected as the president of the assembly and the H.C. Mukherjee and Congress on the 209 was elected as the Congress 209. 13 December 1946, Objective Resolution moved. 22 Jan 1947, Objective Resolution accepted. 3 June 1947, Mountbatten Plan. Indian Independence Act of the 1947. Assembly was made a fully sovereign body. Assembly also became a legislative body. It became a first parliament of free India. Dominions legislature. G.V. Malgankar became the speaker. Constituent Assembly had the 11th session over the 2 years, 11 months, 18 days. 12 session including session on the 24 January 1950, 26 November 1949, signed by the 284th member. Constitution was adopted by the Constitution Day 26 November The Constituent Assembly also performed. 22 July 1947 adopted national flag and May 1949 the ratified the Commonwealth Member of India. 24 Jan 1950 adopted the national anthem and the national song. Both have the equal status. 24th Jan 1950 the elected Rajendra Prasad as a president. Provisions related to citizenship, election, provincial parliament, temporary and the transitional provinces, and the short title contained in the article 5, 6, 7, 8, 9, 60, 324, 366, 367, 379, 380, 388, 391, 392 and 393 come into the force on the 26th November 1949. Important committees. Rajendra Prasad. The Steering Committees, Rule of the Procedure Committee, Provincial Constitution Committee, the Finance and the Staff Committee, Ad hoc Committee on the National Flag, Jawaharlal Nehru, Union Power Committees, State Committee, Union Constitution Committee, a special committee to examine the draft constitution, Sardar Patel, Advisory Committee on the Fundamental Rights, Minorities, Tribal Areas and Executive Areas, Provincial Constitution Committees. The Patabi Sitaramaya, the House Committee, Committee on the Chief Commissioner's Provisions, the Dr. M.K. Munshi, Order of the Businesses Committee, the Aladi Krishna Swami Iyer, the Credential Committee, the G.B. Malwangkar Committee on the Function of the Constituent Assembly, uh, Vadacharya, not an assembly member, ad hoc committee on the Supreme Court. S.K. Dhar, not an assembly member, the Linguistic Provincial Committee. The Drafting Committee set on the August 29, 1947. The plus 7 member, Dr. B.R. Ambedkar Chairman, N. Gopala Swami Iyengar, Aladi Krishna Swami Iyer, Dr. K. M. Munshi, Syed Muhammad Sadadullah, M. Madhav Rao. He replaced B. L. Mittal, who resigned due to the ill health. Uh, T. K. Krishna Marchari. He replaced the D.P. Khaitan, who died in 1948. The facts about the Constituent Assembly. The universal adult franchise was only in provisions added without debate. The seal, elephant. The constitutional advisor, M.N. Roy. The secretary, H.B.R. Layangar. The chief draftsman, S.N. Mukherjee. The calligraphic, Prem Bihari Narayan Raizada. Doctorate, Nand Lal Bose and the Bihar Command. Sources, Board and Features. Sources, Board and Features. The British Constitution, the parliamentary government, rule of law, legislative procedures, single citizenship, cabinet system, uh, prerogative rights, and the parliamentary privileges and bicameralism. Government of India Act of 1935, the Federal Scheme of Office of Governor, Judiciary, Public Service Commission, and the emergency provisions and the administrative details. The U.S. Constitution, the fundamental rights, independence of the judiciary, judicial review, impeachment of the President, removal of the Supreme Court and High Court judges and the post of the Vice President, Australian Constitution, and concurrent list, freedom of the trade, Commerce and the intercourse and joint sitting of the two houses of parliament. The Canadian Constitution, Federation with the strong centre, vesting of the judiciary power in the centre, appointment of the state governors by the centre and advisory judiciary of the Supreme Court. The Irish Constitution, directive principle of state policy, nomination of the member of the Rajya Sabha, and the method of the election of the president. Weimar Constitution of the Germany, a suspension of the fundamental rights during the emergency. Soviet Constitution, the fundamental duties and the idea of the justice, social, economic, and political in the preamble. The Japanese Constitution, a procedure established by the law. The French Constitution, a republic, and the ideas of the liberty, equality, and the fraternity of the preamble. The South Africa and Constitution. The Constitution procedure of an amendment of the Constitution and election of the member of the Rajya Sabha. Historical underpinning. The Regulating Act of the 1773, first act to regulate the affair of the East India Company. In England, the in England, the proprietor would be elect 24 director for the 4 year. The Governor of Bengal changed to Governor General of Bengal. The first Warren Hastings, four-member executive council to assist the Governor General. The Madras and the Bombay Presidency subordinate to the Bengal. And the establishment of the Supreme Court at the Calcutta with a Chief Justice, Eliza Impe, and three judges. The servants prohibited from the taking bribes. The Pitt's India Act 1784, a new body in England named the Board of the Control, with six members for the political affair. The Court of the Director to the manage the commercial affair. The strength of the Executive Council of Governor General replaced for the 4 to 3. The Governor of Bombay, Madras subordinate to the Governor General of Bengal in matters of the war, diplomacy, and revenue. Company territories were called the British possession. Chartered Act of the 1813. The ended the monopoly except trade with China and trade in tea. The company should spend the 1 lakh rupee for the promoting education annually. The allowed Christian missionaries. The authorized the local government to the impose the tax on the person. The Amending Act of the 1781. The ratified the defects of the 1773 Act, the official act of the Governor General Council and the servants of the company exempted from the jurisdiction of the Supreme Court. The Supreme Court jurisdiction extended to all residents of the Calcutta. Also in the Supreme Court in matters of the personal law in there are the separate law for Hindu and Muslims. The Hindu law in applied to the Hindus and Muslim law was law. The Shariat applied to the Muslims. The appeals from the provincial court to the Governor General Council and not a Supreme Court. The Chartered Act of the 1793. the extended monopoly of the company for the next 20 years. The salary of the board of control to be the paid from the Indian revenues, and they gave the veto power to the Governor General of Bengal. The Governor General of the Bengal can appoint justice of peace in the presidency town. The senior official can't be leave the Indian without permission. The company had to pay 5 lakh pounds and annually to the British government. The company can give the license for the individual trade known as the privileges trade or the country uh, trade. The revenue administration and the judicial function separated, leading to the disappearance of the mal mal adalat. The Chartered Act of the 1833. The monopoly ended in China trade and the exception were abolished. The administration was centralized. The Governor General of Bengal became the Governor General of India, first William Bentinck. The governors of the Bombay and Madras were the deprived of the legislative powers. The earlier law was were known as the regulation, but from the now onward known as the Act, introduced law member first Macaulay in the Governor General's Council. The Law Commission was to be the constitute for the consolidation and the confederation of Indian law. The service under the company government were the open for all Indians, but this was not implemented. All restrictions on the European imagination and the acquisition of the property were tilted. The company should take a step for improving the condition of the salary. Act 5 of the 1843 and abolish the salary. Chartered Act of the 1853. They reduced the strength of the court of the director from the 24 to 18. Introduce open competition for the civil service. First Indian Satyendra Nath Tagore in 1983 to 84, 1963 to 64. The separated executive and legislative function of Governor General of India. For the legislative function, the Governor General Executive Council will be council 6 additional members. Governor General plus the Executive Council 4 plus the Commander in Chief plus 6 member Indian Central Legislative Council. The Governor General has the power to veto any proposal. The Indian Council Act 1861. India has the non-official member of the Viceroy, the expanded council, the Raja of Benares, the Maharaja of the Patiala, and Sri Dinkar Rao. They started the process of the decentralization by the restoring the legislative power to the Bombay and Madras. The Viceroy can issue the during the emergency. The new Legislative Council for the NWF, Bengal and Punjab. The statutory recognition to portfolio system introduced by the Canning Government of India Act 1858. The also known as the Act for the Good Government of India. The Governor General of India is changed to the Viceroy of India. Abolished the Board of the Control and the Court of the Director. Ended the double government. The Secretary of State for India, member of the British Parliament, was given control and the authority of Indian administration. They abolished a 15-member Council of India to assist the Secretary of State for India. The Secretary of State can be sued in the India and in England The Indian Council Act 1892. The Council got the power to discuss the budget and ask the question to be the executive demanded for the Congress. The member of the additional non-official member in the central and the provincial legislative council was increased, but the official majority was maintained. The some non-official member of the central legislative council to be nominated by the viceroy and the recommendation of the provincial legislative council and the Bengal chamber of the commerce and of the provincial legislative council by the governor on the recommendation of the directive board and municipalities, universities, trade association, zamindars and the chambers. Indian Council Act of 1909 Morley Minto Reform introduced separate electorate for the Muslim, father of the communal electorate. The size of the legislative council both at the central and provincial in laws. The introduced the elections indirect and in the provincial legislative council and official members can be in the majority, allowed the association of the Indians with the executive council of the viceroy and the governors. First, Satyendra Prasad Sinha. The supplementary question were allowed. It provided for the separate representation of the Chamber of the Commerce and Presidency, Corporation of the University and Jamindars. The Government of India Act 1935. The provision of the All India Federation including the princely estate and the provinces never come into existence, abolished the diarchy in the provinces and the introduced provincial authority. The bicameralism in 6 to 11 provinces, abolished the Council of India, the legislative power with the Viceroy. The reservation for the depressed class, scheduled caste, women and labor workers. The established RBI and Federal Public Services Commission and the Provincial Public Service Commission. The separate Burma from India. The created two new provinces of Odisha and the Sindh. The provided by the Auditor General and the Federal Railway Authority. The extended franchises about 14% population got the voting rights. The Government of India Act 1990 Montesquieu Chelmsford Reform. The separate electorate extended to Sikh, Christian, Anglo-Indian. The Secretary of State for India will receive salary from the British revenue. Diarchy in the provinces. Example, division of the provincial subject in the transport and reserved categories. The reserved subject, example, police, land, revenue, administration of the justice, irrigation, and the were under the complete control of the governor. The bicameral legislature at center. The some powers of the Secretary of State were assigned to the High Commissioner of the Indian Land. Clearly, clearly defines the jurisdiction of the central provincial governments by the separating the central and the provincial subjects. The ICS exam to be held in India. First 1920 in the Allahabad. The women got the right to vote, not all. The Indian Independence Act 1947. India as an independent act sovereign state for the 15 August 1947. Two independent dominance of domination of the India and the Pakistan were created. The Constituent Assembly of the two dominions can frame the adopt the any constitution. The lapse of the British paramountcy over the Indian princely estate and they can join any dominion. The until a new constitution is the formed, the dominion to be the governed by the government of the India Act 1935. The abolished viceroy and the provided for the governor general. The abolished office of the secretary of state. Preamble. The American Constitution first to be began with the preamble. Reflect the mind makes the Constitution. Reflect the principles of the UDHR Universal Declaration of the Human Rights 1948 along with the fundamental rights DPSP and fundamental duties based on the objective resolution. Objective resolution includes the more than the preambles, the freedom of the thought, expression, belief, faith, worship, vocation, association, and the action subject to the law and the public morality. Safeguard for the morality backward and article. Promotion of the world peace and the welfare of the mankind attain the faithful and honored the place in the world. Does not contain the democratic scholar socialist and the unity and the integrity. Identity card of set by the Amen Palakiwala. A horoscope set by the Amen Munshi. Element. Source of the authority of the Constitution. People of India. Nature of the Indian state. Socialist, secular, democratic and republic polity. Objective of the Constitution: justice, liberty, equality, and fraternity. Date of the adoption of the Constitution: November 26, 1949. Keyword: the sovereign. The term means that the India has to independent authority and it is not a domination of any other external power and it is free to conduct its own affair. The socialist. The preamble means the achievement of the socialist and ends the thought democratic means it promotes the democratic socialism which holds the faith and mixes the economic and where the both private and the public sector coexist side by side. Secular. The term means that all the religion in India get equal respect, protection and support from the state. The preamble. The American Constitution first began with the preamble. Reflect the mind of makers of the Constitution. Reflect the principles of the UDHR Universal Declaration on the Human Rights 1948 along with the fundamental rights DPSP and fundamental duties based on the object resolution. The objective resolution on includes the more than the preamble. The freedom of the thought, expression, belief, faith, worship, vocation, association, and action. The subject to the law and the public morality. The safeguard for the morality backward the tribals. The promotion of the world peace and the welfare of the mankind attain the rightful and the honored the place of the world. It does not the contain the democratic, secular, socialist, and unity and integrity. The identity card said by the M.N. Palikewala. The horoscope said by the M.K. Munshi. Element. The source of the authority of the Constitution. People of India. The nature of the Indian state. socialist, secular, democratic, and republic polity. The objective of the Constitution: the justice, liberty, equality, and fraternity. The date of the adoption and the Constitution: November 26, 1949. Keyword: sovereign. The term means that the India has its independent authority and it is not a dominion of any other external power, and it is free to conduct the own affair. As socialist, the preamble means to achieve the socialist and end through the democratic means. It the promote the democratic socialism, which is hold the faith and makes the economic where the both and it private and it promote public sector of the exist side by side. Secular. The term means that the all of the religion in India get the equal respect, protect, and support from the state. The Western secularism, Indian secularism. Western secularism, complete separation, no role in the religious reform, no intervention, negative concept of secularism, and no state support to any educational institution run by the religious minorities. Indian secularism. The principled distance role of the state promoting religions, and the positive concept of the Sarva Dharm Sambhav. The state can aid educational and institution run by the minorities. Democratic refers to the constitution that gets the authority from the will of the people expressed in the election. Democracy is not limited to the political aspect but also social and eh, economic. India is a representative democracy rather than a direct democracy like Switzerland. Also, John Locke called it is a system of government by the consent. The republic indicate the head of the state is elected by the people. Example: elected president is India. It also the denotes the absence of the privileged class. Example: public office are the open it everyone. Liberty. It means the absence of the restriction out but not in the absolute sense on the activities of the individuals, and at the same time the providing opportunity for the development of individuals and personalities. However, liberty is not absolute but limited, fulfilling the maximum: no law, no liberty. The equality, it means the absence of the special privileges to any section of society and provision of adequate opportunity for all individuals without any the discrimination. The fraternity, it means a sense of the brotherhood. Is it preamble a part of the constitution or not? Berubari Union Case 1960, not part of the constitution. Keswananda Bharati Case 1973, yes, part of the constitution. LIC of India Case 1995, yes, integral part. Overall part of the constitution and can be used in the interpretation of the coast, but is a non-justiciable in nature and independently right, neither a source of power to legislature nor a prohibition upon the power of the legislature. Can the preamble is to amend under the Article 368. Keswananda Bharati Case 1973. Yes, can be amended subject to the basic structure. 42nd Constitutional Amendment Act 1976 added socialistic, secular, and integrity. The Union and its territory. Article 1. Name and territory of the Union. India, that is the Bharat, shall be union of state. Although the word union is begun used in the place of the federation, yet from the various judgment it is clear that the India constitution is federal in nature and the federalism is the basic structure. Indian Federation is not a result of the agreement among the states coming together a model like the American Federation and the state of no right to the secede holding together model from the Federation. Territory of the Territory of India can be classified as a territory of the state, union territory, and the territory that may be acquired. The Article 2. The administration or the establishment of the new state. Parliament may be law admit into the union or the establish new state on such a terms condition as the it think fit. Article 3. Formation of the new state and the alternation of the area's boundaries or the name of the existing state. Parliament may, by the law, a. Form a new state by the separation of the territory from the any state or the by anything two or more state or the part of the state or the by the unity any treaty to be part of the any state. B. The increased area of the state. Diminish the area of any state. D. Alter the boundary or any state. Alter the any name of any state. For the above changes, bill needs the prior recommendation of the president. Also, the President should refer to the bill to the concerned state legislature for their the view in the specific time period, but the view of the state are not binding. The further bills can be passed by the Parliament through the simple majority. The Article 4. Any law referred to the Article 2 or Article 3 shall contain such provision of the amendment of the any first schedule and the fourth schedule shall not be deemed as the amendment under the Article 368. The evolution of the state and union territories. The integration of the around 550 provincially state after the independence. The integration led by the fourfold the classification with the 29 states. Demands of the linguistic resignation lead to Dhar Commission, June 1948, chaired by the S.K. Dhar, plus a report in December 1948, and the recommended the reorganization of the state on the basic administration convenience rather than the in linguistic factor. The JBP Committee, December 1948, Jawaharlal Nehru, Vallabhbhai Patel, Patabi Sitaramaiah, no chairman, plus the for recognition rejection language as the basis. 1953, first linguistic state of the Andhra was created from the Madras state. Fazal Ali Commission, State Reorganization Commission, December 1953. Chairman Fazal Ali, member of K.P. Parikar and the H.K. Kunuz, plus the submitted report in 1955 that reject on the language on the state but broadly accepted language as the basis, plus recommended abolition of fourfold classification of state by the State Reorganization Act 1956 and the 7th Constitutional Amendment Act 1956. A rearrangement were done by the resulting in the 14 state and 6 union territories. Kerala is equal to Travancore plus Kochi plus South Kannada. Andhra Pradesh is equal to Andhra plus Hyderabad. मध्य प्रदेश इक्वल टू मध्य भारत प्लस विंध्या प्लस द भोपाल. New UT is equal to locative Minicoy and the Mini Divine the island for the territory detached from the Madras state. New state 1960 Maharashtra and Gujarat bifurcated 1961 Andhra and Dadar and Nagar Haveli 10th Constitutional Amendment Act 1962 Goa Daman and the 12th Constitutional Amendment Act French hand over Pondicherry 4th 14th Constitutional Amendment Act 1963 Nagaland 1967 Haryana 1971 Himachal Pradesh 1974 The Sikkim 36 Constitutional Amendment Act 1975 Sikkim full-fledged state referendum held in the Sikkim 1987 Mizoram Arunachal Pradesh and Goa 2000 Chhattisgarh Uttarakhand and Jharkhand 2014 Telangana 2019 Union Treaty of the Ladakh Jammu and Kashmir J&K Reorganization Act 2019 bifurcated earlier state of Jammu and Kashmir. Citizenship. The citizenship has been defined as the full equal membership of the political community in which the individual is entitled for the certain rights. The Constitution deals with the citizenship from Article 5 to 11 under Part 2, but detailed provision regarding it is absent. It does not lead with the problem of acquisition or losses of citizenship subsequent to it is the commencement. It empowers the Parliament to enact a law provide for the such matter and the may other matter relating to the citizenship. Accordingly, the Parliament has the entitled the Citizenship Act 1955, the single citizenship. Despite the federal structure, India does not provide dual citizenship unlike USA. There is only one citizenship on the domicile. There is a only single citizenship, example Indian citizenship. However, the Indian Constitution does not define the citizenship. First, according to the Constitution, citizens are Article 5. A person who is a domicile in India, born and any one of the parent is an Indian descent or the resident of the India from 5 years. Article 6 People who come from Pakistan. Article 7 People who went to Pakistan and return back to India before the um, commencement of this constitution. Article 8 Person of Indian origin residing outside India by registration. Article 9 Person voluntarily acquired the citizenship of the foreign state not be a citizen. The Citizenship Act 1955 provides for the acquisition or loss of citizenship after the commencement of the Constitution. This act provides five ways for the citizenship. Birth. If a person is born in India and both the parents are the Indian or one of the parents is an Indian and the other one is a not illegal migrant descent. An individual born outside India, it both or either parent is a Indian citizen and not a illegal migrant are the considered Indian citizens by the descent if their birth is registered or in any Indian mission post abroad within 1 year. Uh, Registration for the individual of Indian origin who have been reside in India for 7 years, reside by the any country outside India are the married to a citizen of India and have the been a OIC card holder for 5 years. Naturalization A central government may be satisfied and not be applicant in the qualified for the naturalization under the provisions of the third schedule grant him the certificate. The incorporation of the treaty section 7. If any treaty become a part of India and central government or may be the orders specify the person who shall be citizen of India by the reason for their connection with their that territory. The Citizenship Act 1955 prescribed three ways to losing the citizenship. The renunciation. Any citizen can renounce the citizenship by the making a declaration. When a person renounces the citizenship, every minor child of that person also loses citizenship. When such a child attains the age of 18, he may resume the citizenship. Uh, Termination. If an Indian citizen willing to acquire the citizenship in another nation, his Indian citizenship is terminated. This provision is not applicable during the time of the war. The deprivation, the compulsory termination of the citizenship is India by the central government. A. If obtained the citizenship by the fraud, as on the disloyalty by the Constitution of India, the citizen has unlawfully traded the communicated with the enemy during the war. The D. That citizen has within the 5 years after the resignation or the naturalization been the imprisoned in any country for the 2 years. The, the citizen has been the ordinarily the resident but of the for 7 years the continuously a foreigner once grants the citizenship can be the deprived of it. In Indian, both a citizen by the birth as well as a naturalized citizen are the eligible for a office of the president, while in USA only a citizen by the birth and not a naturalized citizen is eligible of the office of the president. The Citizenship Amendment Act 2019. The legislation grants citizenship of the six minorities Hindu, Sikh, Buddhist, Jain, Parsi, and Christian, fulfilling the religion persecution from Pakistan, Afghanistan, and Bangladesh. The citizenship will be granted to those who entered India from the country on or before December 31, 2014. The relaxation of the naturalization process of acquired citizenship. Uh, at Citizenship Constitutional Amendment Act 2019 amend the Citizenship Act of the uh, 1955, and the amendment relaxed the residence requirement for the naturalization of these migrants from the 11 years to the 5. The exemption from the criminal cases for deportation. The Constitutional Amendment Act exempt the member of the six communities from any criminal case and the deportation under the Foreigner Act 1946 and the Passport Act 2019-20. The exemption to the Act, the provision on the citizenship for the illegal migrant will not apply to the two categories. The state protected by the inner line permit area covered under the sixth schedule of the Constitution. The no resident Indian NRI, the person of the Indian origin PIO, the overseas citizens of the India OIC card holder. The non-resident Indian (NRI), an Indian citizen who is ordinarily residing outside India and holds the Indian passport. All the benefits that are available to the Indian citizen subject to the Notification issued by the government from the time to time. No visa is required. Not required to the register with the local police authority in the India. The all activities can be the undertaken. He or she is an Indian citizen. The person of the Indian origin PIO, a person who are the ancestors were the Indian nationality and who is presently holding the another country's citizenship nationality. He or she is holding the foreigner passport. No specific benefit. Visa is required. Yes, he if the period of the stay from more than the 180 days. The activities as a part of the type of the visa obtained. Citizenship Act 1955. A person has to be the ordinarily resident in India for 7 years before making the application for the resignation. The overseas citizen of Indian OCI card holder. A person registered as an the overseas citizen of Indian OIC cardholder under the Citizenship Act 1955. The multiple lifelong visa visiting India for the any purposes required a special permission to the undertake the research work in India, exempted from the registration with the Foreigner Regional Registration Office FRRO. The party with the NRIs respect of the all facilities available to them in the economic, financial, and the educational field, except in the matters relating to the acquisition of the agriculture and plantation and the properties that treated at the part of the NRIs in the matter of the inter-country adaptation of the Indian children that treated at the any part of the resident Indian national in the matter of the tariffs on the tariffs fair and fair domestic secret in India. I can visit India without visa for the lifelong. The not required to the register with the local police authority in India. All the activities except research work for the special permission is required from the Indian Mission Post or FFRO connected. As per the Citizenship Act 1955, a person registered as an the OCI cardholder for the 5 years and who is the ordinarily resident in India for the 12 months before the making and the application for the registration is eligible for a grant of the Indian. The fundamental rights. Fundamental rights refers to the set of the essential liberty and the entitlement and granted to every citizen by the Constitution for protecting the citizen from the arbitrary state action and the ensuring the basic human right and the freedom. The inspired by the Constitution of the USA, a Bill of the Right, a Bill of the Right prohibited by the government the from the use of the action against the right to the individual and ensure the remedy in the case there is a violation of these rights. The fundamental rights are also described as the Magna Carta of India. The named as the become they are the granted by the protected by the Constitution. The Article 12 to 35 Part 3 of the Indian Constitution provide for the six fundamental rights: a right to equality, Article 12, 14 to 18, a right to freedom, Article 19 to 22, right against exploitation, Article 23 to 24, A right to freedom of religion, Article 25 to 28. Cultural and educational right, Article 29 to 30. A right to constitutional remedies, Article 32. Originally the Constitution provided for the seven fundamental rights. However, the 44th Amendment Act removed by the right to property from the list. It was the instead made the legal right under the Article 300A in the Part 12 of the Constitution, the feature of the fundamental rights. Some of these rights are available only to citizen, while other are available to the all person, whether the citizen, foreigner, or legal person like the corporation and the companies, etc. All these rights are available against the arbitrary action of the state. However, some of they are also against the action of the private individuals. Some of these rights are the negative and the character as the the place limitation on the authority of the state. While the other the positive in the nature in they are confirmed certain privileges on the individuals. These rights are the protect and safeguard by the Supreme Court. Hence the aggrieved person can directly passes to the Supreme Court and without the necessity appealing against the judgment of the High Court. These rights are not considered the sacrosanct or the permanent. They can be amended by the Parliament through the constitution amendment process provided by an amendment do not violate on the basic structure of the Constitution. During a state of the national emergency, certain rights can be suspended by the President except those granted under the Article 20 and 21. The Parliament can restricted on the abrogate the application of this right on the member of the armed force, paramilitary forces, police force, intelligence agency, and the Angular services. Article 33. The most of them are directly enforceable, while the other can be enforced based on the law, especially made to give the effect to them. Only the Parliament can enact law regarding this right to be ensured. Uniformity across the nation. Article 35. Every right or duty involves the legal obligation by the which two or the more person are around the together. And for the instance, you can't be enjoy the right to clean environment if the over the do not perform their the duty of the protecting and conserving the environment. So right connectivity with duties. The liberal democracy, the constitutional government based on the formal, usually legal rules, the guarantee of the civil liberties and individual rights, the fundamental rights available to the everyone. Article 14. The right to equality before the law and the equal protection of law. Article 20. The protection of the respect of the conviction for offense, the double jeopardy and the self-discrimination. The Article 21. The right to the life and the personal liberty. Article 21A. The right to education for the children between the age of the 6 to 14. Article 22. The protection against the arrest and detention in the certain cases. The Article 23. The provision of the traffic in the human beings and the forced labor. Article 24. The prohibition of the employment of the children in factories and the hazardous employment. Article 25 to 28. The freedom of the religion and the religious affair. the fundamental rights available only to the citizen. The Article 15, the prohibition of the discrimination on ground of religion, race, caste, and place of the birth. Article 16, the equality of opportunity in the matter of the public employment. Article 19, the freedom of the speech and the expression and assembly, association, movement, and residence of the profession. Article 29, the protection of the interests of the minorities by the conserving their the culture and language of the spirit. The Article 30, the right to the minorities to the establish and the administer the educational institution. The Constitution of the India, Part 3 and Fundamental Rights. The right to equality, the equality before law and equal protection of the law. Prohibition of discrimination on the ground of religion, race, caste, sex, or place of birth. Equal access of the shop, hotel, well tank, and the bathing ghat road, etc. Equality of the opportunity in the public employment. Abolition of the untouchability. Abolition of the title. A right to freedom. The protection of the right to the freedom of the speech and expression, assembly in peacefully from the association and unions move freely throughout the territory of India, the reside and the settle in the any part of the India, the practice any profession or to the carry on their the occupation, trade and or businesses, and the protection of protection in respect of the conviction for offense, the right to the life and the personal liberty, right to education, protection against the arrest and the detention in the certain case, right against exploitation, prohibition of the traffic in human beings and the forced labor, prohibition of the employment of the children in the hazardous jobs, a right to the freedom of the religion, the freedom of the conscience and free profession and the practice and the progress of the religion, freedom to the manage the religious affair, the freedom to the pay the tax for the promotion of the any particular religion, the freedom to the attend the religious instruction and worship of the certain educational institution, cultural and educational right, protection of the language and culture of the minorities, and right to minorities to establish educational institutions, a right to the constitutional remedies, a right to the move the court to the issue the direction or the order, and rights of the enforcement of the rights. The definition of the state, Article 12. Article 12 defines the term state for the Part 3. Accordingly, the state government of the Parliament of India and the government and the legislature of the each of the state and all local authority within the Treaty of India or under the control of the government of India. The Supreme Court, even a private body or the uh, agency working as the instrument of the state falls within the meaning of the state under the Article 12. The Sukhdev versus Bhagwat Ram case, LIC, Life Insurance Corporation of India, NGO, Oil and Natural Gas Corporation, and the IFC, International Finance Corporation, were held the two states as the perform the very similar function which is seems to be the governmental and the sovereign function. Article 13. According to the if any law inconsistent with the fundamental rights, then that law can be declared as a void. The term law has been the broad meaning it can be the parliamentary law or the state law, those are ordinances. तीसरा customs or sovereignty. Fourth, by law and delegated by the legislation with any notification. The word law do not apply for the personal law. Article 13 declares that a constitutional amendment is not a law and hence the can't be the challenge. But the Supreme Court held in the Keswananda Bharti case that can be challenged on the ground that is the violation of the fundamental rights. Article 14. The state shall not deny any person equality before law or equal protection of law within the territory of India. This provision confirms the right to all persons, whether citizen or the foreigner. However, moreover, the word person includes the legal person versus statutory corporation, companies, registered societies, or the any other type of the legal person. Equality before the law, negative concept. No special privileges to any person. No person is the above the law. Equal treatment of the all person to the law. The equal protection of the law, positive concept. Equality or the treatment under the equal circumstances, similar application of the same law to all people who are the similarly situated. Like should be the treated alike without discrimination. Rule by the law is the part of the basic structure. Exception to the Article 14. The Article 361 which immunises the President and Governor for criminal proceeding, answerability to the court and the imprisonment. International conviction related to immunity like the Vienna Convention for the diplomatic official etc. Uh, Article 105 and 194 for PM and MLA privileges, which is still uncodified. The for Article 31 B, C are the directive principle of state policy, which are there are the affirmative action for the disadvantaged section. The Supreme Court of the India has held in the some judgment Nagaraja case and that the reservation policies made under the Article 6 6 Section 4 of the Constitution of the India would be the limited by the Article 335 for the maintenance of efficiency or the administration. Article 335. The claims of the Supreme SC and ST to service of the post shall be taken into the consideration with the maintenance of the efficiency of administration in the making the appointment to the service and the post and the connection with the affair of the union or the state. However, would the efficiency is not defined. The remember made the service that the question of the polity which is seeks to be the state that this the xyz is defined in the constitution is the generally wrong unless you are answer of the legislation which is conform on the executive or the administrative authority on the unguided any uncontrolled the discriminatory power in the matter of the application of the law violation article 14 of the constitution of india. Main feature of the rule of the law. 1. Limitation of power. 2nd. Equality before law. 3rd. Liberty and the civil rights. Article 15. The state shall not be discriminate against any citizen or ground only of religion, race, caste, sex, place of birth, or any of them. It means that the discrimination on the other grounds can be accepted. Second, no citizen shall be ground only on the religion, race, caste, sex, or place of birth, or any of them. Be a subject to the any disability, liability, restriction, or the condition with the regard to the asset to the shop, such public restaurant, hotel, place of the public entertainment, or this was the wells, tanks, bathing ghat, or the road, place of the public restore maintained wholly or partially out of a state fund or the dedicated by the use of the general public. Exception. The special provisions for the pala women and children like to be the policy reservation. Second, advancement of the any socially and educationally backward classes of the citizens. Uh, SEBC or for the scheduled caste and the scheduled tribes. Third, administration to be the educational institution including private, whether the aided or the unaided by the state, the except the minority educational institution to the SEBC. Fourth, advancement of the any educationally weaker section in the education. 10% quota is allowed except the minorities educational institution. 103 Constitutional Amendment Act 2019. Article 16. There shall be the equality or the opportunity for all citizens in matter relating to the employment or the appointment or to the any office under the state, and no citizen shall on the ground only on the religious, race, caste, sex, or the set place of the birth, resistance, or the any them the eligible for the discriminated against the respect to the any employment or any office under them the estate. The aspirant must be the note that the in Article 15 word descent and the place of the resident not mentioned. Exception. The Parliament can prescribe the residence as a condition for the certain employment or appointment in a state or the union territory or the local authority or other authority. A reservation to the SEBC by the state. A law can be provided that the incumbent of an the office related to the religious or a denominational institution or the matter of this governing body should be belong to the particular religion or the denomination. The reservation to the EWS by state. The sum of the sum related case laws under the amendment. A. M. Nagarajan case, the Supreme Court approved the Parliament decision to the extend the reservation for the SCs and STs include the permission. Second, the Indian Sovereign Judgment 1992, the total reservation shall not exceed 50%. 76th Amendment Act 1994, Tamil Nadu 96% reservation in ninth schedule protected from the judicial review. 77th Amendment Act 1995, reservation in the promotion in the favor of SC and ST is they are not adequately represented. 81st Amendment Act 2000. It empowers the state to the fulfill backward vacancy even they can across the 50% ceiling. The 85th Amendment Act 2001. It provides the consequential seniorities for the SC ST within the three retrospective effect from the June 1995 and the 2003 and the Amendment Act 2009. Amend Article 1516 provides for the 10% reservation in job and the educational institution for the EWS. Article 17 untouchability is abolished and it is a practice in any forms prohibited uh, forbidden. The enforcement of the any disability arising out of the untouchability shall be an offence punishable in accordance with the law. It refers to the social disability imposed on the certain classes of the person by the person of their birth or the certain caste. Hence, it does not cover the social boycott by the few individuals or the exclusion from the religious services. Untouchability neither defined in the Constitution nor the protection of the Civil Rights Act 1955. Article 18. The abolition of the title. A, prohibits a state from the conferring any title on anybody except military academics. The citizens can't accept any title from foreign state. A foreigner makers from the Indian government can't accept a title from the foreign state without the consent of the president. The no citizen or foreigner holding any office of profit shall not accept any present emolument without any consent of the president. The Bharat Ratna Padma Award no not a title, not to be used as a suffix prefix to the name of the awardees. The Balaji Bhagwan case. The court held that the national award are not the title under the Article 18. The Article 19. First, the right to freedom is the fundamental human right that encompasses various dimensions of the individual liberty and the autonomy. It is the recognized, protected, and numerous international human rights. The instruments such as the Universal Declaration of Human Rights (UHDRC). The second, these six rights are the protected only against the state action and the not a private individual. The originally Article 19 of the Indian Constitution continued seven rights. However, the rights is the acquire, hold, and the dispose the property and is were deleted by the 44th Amendment Act of the 1978. These rights are the available only to the citizen and the shareholders of the company. They are the not available to the foreigner or the legal entitled like corporation and companies etc. The responsible restriction can be the imposed by the state and these six rights only on the grounds mentioned in the Article 19 itself, not to be any other grounds. Article 19 Responsible Restriction remarks the right to be expressed one's view, opinion, belief, and the conviction. Responsible restriction, sovereignty and the integrity of India, security of the state. Remark also include the right to the propagate one's the own shall is the other view. The freely by the word or the mouth, writing, printing, and the picturing or the any other the manners. The reasonable restriction, the friendly relation with the foreigner state, the public order and the decency or the morality, the contempt of the court, the defamation and the incitement to the any offense. The remark, the against the imposition on a pre censorship on the newspaper, the demonstration of the picketing out of the not right to the strike, right against the band called by the political party or the organization. हाँ, Article 19 में every citizen has to the right to the assembly and peacefully without arms, including the right to the hold the public meeting and the demonstration and then they take out the procession. A reasonable restriction. the sovereignty and integrity of India, the public order and the morality. Remark. This right does not include in the right to strike, and this right to the obtain the recognition of any association and formed is not a fundamental right. As per the Supreme Court, the trade union have the no granted right to the effective and the bargaining or the right to the strike or the right to the declare a lockout. Every citizen has the right to the remove freely throughout the territory of the country, and one can move freely between the state or the within the state. The interest of the general public. For the example, Supreme Court has ruled that the freedom of the movement of the prostitute can be the restricted on the grounds of the public health and on the public morals. The protection of the interest of the any scheduled tribes, for the example, the government the restriction of the entry of the outside the tribal area. Remark me. It is to be the noted that the Article 19 protected only the internal movement of the freedom of the movement. The external movement, example, move out of the country, is the deal with the Article 31, the right to life and the personal liberty. The every citizen has the right to the reside and the settle in the any part of the treaty of India. The interest of the general and the public and the protection of the interest of the any scheduled tribe also includes the right to the temporarily stay in the any part of the country, the right to the stay in the any part of the country. The all citizens are the given the right to the practice any profession and the pursue the any occupation, trade or the businesses of their the choice and grounds of the interest of the general public. The right does not include the right to the carry on the profession, businesses, trade and occupation that is immoral or the dangerous. The state is empowered to the prescribe that the technical or the professional qualification is necessary for the for practicing any the profession or the any carrying on the any occupation, trade or businesses. And this is mean that no objection and can be the made when the state carries on the trade, businesses, industry, service monopoly or to the inclusion of the citizen or in the competition with the any citizen. Protection in the respect of the conviction for the offense, Article 20. This right protects against the arbitrary and excessive punishment of the any accused person, whether a citizen, a foreigner or the legal person like the company or a corporation. The no ex post facto laws, no retrospection. No person shall be the convicted by the applying law retrospectively, and no penalty greater than the applies only to the criminal law, not to be the civil, and the tax law do not apply to the preventive detention prescribed. And no person shall be the convicted of the any offense except for violating the law of the force to the time at the commission of the act, and no double jeopardy. And no person shall be the persecuted and punished for the same offense more than the once. The available only for the proceedings before other court of law or the judicial tribunal, not before the departmental and the administrative authorities. No self discrimination. No person shall be the witness his own case. The this protection extends to the both oral evidence and the documentary evidence. This protection does not extend to the following: the compulsory protection of the materials objects, the compulsion to the given the thumbs, the impression and the expression, the signature and the blood expression. The compulsory prohibition of the body and this protection extend only the criminal proceeding and not to a civil proceeding or the other the proceeding which are the not to be criminal in nature. Article 21. No person shall be the deprived to their the life except according to the procedure established by the law. And this means that the every individual has the right to the live and their the life can't be the action they are except in accordance with the prescribed legal procedure. First, A.K. Gopalan versus State of Madhya Pradesh held that the personal liberty means a liberty of the body which is freely from the asset or the detention from the false detention and the would word law means that a state made law law only so that clearly this was the narrow interpretation of the word personal freedom of the law. The protection available only against the arbitrary executive action and not from the arbitrary legislative action. Thus, the state can and deprive right to the life and personal liberty of the person based on the law. The reasoning given by the Supreme Court was that the expression procedures established by the law used Article 21 is different from the expression due to process of law. A due process of law, it is a doctrine that not only the check in there is a law to be derived that life is a personal liberty of the person but also ensure that the law is made fair for just. The procedure established by the law it means that the enacted by the legislature or the concerned body is wide valid only in the conducted procedure has been the followed. Second, Menaka Gandhi versus Union of India 1978 took a withdrawn interpretation of the Article 21. The overruling the judgment in the Gopalan case, it held that the origin of life, personal liberty, and the person can be the deprived by the law provided by the procedure prescribed by the law is the responsible, fair, and the just. Introduced the concept of the dual procedure by the law. Thus, the now protection under Article 21 is available not only against the arbitrary executive action but also against the arbitrary legislative action. Right to education Article 21A. This article declares that the state shall provide freely compulsory education to all, and the children of the age of 6 and 14 years is such as a manners such as determined by the state. It is to noted that this provision makes the only the elementary education of the fundamental right and not the higher professional education. Its provision was added by the 86th Constitutional Amendment Act of the 2002. This amendment added the change in subject matter of the Article 45 to direct that state shall endeavor endeavor to the provided early childhood and the care and the education to children until they are completed at the age of 6 years. Second, new fundamental duty under the Article 51A, that is a duty of every citizen to provide opportunity for the education to his children between the age of 6 to 14 years. The Supreme Court in this various ruling added by the some their right to in the Article 21 like a right to the decent environmental including pollution-free water, air and the protection against hazardous industries, a right to livelihood, a right to shelter, right to health, a right to free and legal aid, a right against the solitary confinement, confinement, a right to the speedy trial, a right against the handicrafting, right against the inhuman treatment, right against the delayed execution, right to travel abroad, right to the information, etc. Article 22. Protection against arrest and detention provides safeguard for the person who are arrested or the detained. 1. Ground of the informed. The right to the consult and the defend by the lawyer. Right to the producer by the magistrate within the 40 hours including journey and the holidays. Second, shall not be detained for the more than the authorized by the magistrate. And the two kind of the detention, punitive detention and the punish a person for the offense committed by him. Second, preventive detention, detention of the person without trial and conviction in court. The under the preventive detention can be detained for the 3 months beyond the divisionary and the board shall be permitted. The board shall consist of the judges of the High Court. The Constitution of the Indian exempted state from the providing the legal consult. The parliamentary by the law can be increased the period of the preventive detention for the more than 3 months without obtaining the opinion of the advisory board. The parliament has the executive authority to make the law the preventive detention or the person connected with the defense and foreign affairs and security of India. Both Parliament and state legislature can currently make a law the preventive detention for the person connected with the security of a state, maintaining the public order and maintenance of the supplies and the service essential for the community. According to the Preventive Terrorism Act 2002, confession of the accused before the police can be the used as the evidence. The provision of the trafficking in human beings and the forced labor, Article 23. The prohibits and the trafficking in human beings and all forms of the forced labor such as the beggar, bandit labor, etc. Any violation of this provision shall be the offense punishable by the law. And this right is available to the both citizen and non-citizen. It protects the individual not only against the action of the state but also against the action of the private person. The exception. The state can impose the compulsory service or the public purposes such as military service, social service, etc., which is not bounded by the pay. However, the imposing the such service and the state can't be discriminated based on the grounds of the religion, race, caste, sex, or class. Prohibition of employment of the children in factories, etc. Article 24. This provision prohibits the employment of children under the age of 14 in factories, mines, or other such hazardous activities. However, it does not forbid the employment in the harmless or the non-hazardous activities. The Article 25, a right to the religion. First, all persons are equally entitled for freedom of the conscience and the right to freely profess and practice and the propagate religion. Article 25 covers not only the religious belief doctrines but also the religious practice rituals. Moreover, these rights are available to the all persons, citizens, and as well as the non-citizens. However, these rights are subject to the public order, morality, health, and the other provisions related to the fundamental rights. The nothing to be this article shall be affect the operation of any existing law and the prevent a state and the making any law to the regulate the restrict any economic financial and the political other secular activities and the associated with the religious practice The provide for the social welfare reform and other open Hindu religious institution of the public character and to be all classes with section of the Hindus. The Article 26 Freedom of the manage religious affair. The subject to the public order, morality, health, and very religious domination of the any section, therefore, thereof all shall have the right to establish and maintain the institution for the religious and the charitable purposes, to manage its own affair in matter of the religions, to own the and acquire the movable and the immovable property, to administer and such property to accordance with the law. The like the right to be Article 25, the right under the Article 6 are also subject to the public order, morality, and the health, and not subject to the other provision relating to the fundamental rights. The necessary condition by the Supreme Court to be the considered as a religious non-demolition. Demolition. First, the system of the belief. Second, common organization. Third, the distinctive name. Article 27. Freedom as a payment of the tax or the promotion of the any particular religion. There can be no tax, no proceeds of which are the directly used for the promotion or the maintenance of the any particular religion by the religious domination. Any particular religion and religious any particular religion and religious domination. This provision prohibits only the levy of the tax, not a free. Thus, the free can be the levied on the pilgrims to the provide them some special services or the safety measures. Article 28. Freedom as the attendance of the religious instruction or the religious worship of the certain the educational institution. These articles permit the educational institution that are the maintained by the religious groups of the determined by religious instruction. The educational institution. The institution wholly maintained by the state. The institution administered by the state but established under the Indo endowment or trust. The institution recognized by the state. Institution receiving aid from the state. Religious instruction completely permitted. The permitted or the voluntary basis a student may or may not be attend. The permitted or voluntary basis a student may or may not attend. The cultural and educational rights safeguard for right to linguistic and religious minorities. Article 29. A protection of the interest of the minorities. Article 29A. This provides any section of the citizen residing in the India having the distinct culture, language, and the right to the conserve their the cultural and linguistic scripts. Article 29. Second, the state shall not deny admission or into educational institution maintained by the those who had aid received aid to the any person based on any race, religion, caste, language, or any of them. The Supreme Court also held that the right to the conserve the language and include the right against for the protection of the language. Hence, the political speech or the promises made by the conservation of the language of the section of the citizen does not amount of the corrupt practice under the Representation of the People Act 1951. Article 30. Right of the minorities to establish the administration educational institution. This right to given the minority to form the governor there on the educational institution. Article 30 is also called the Charter of Education Right. Article 30A 1. All religions and the linguistic minority have the right to establish the administered educational institution of their choice. Article 30 Second, the state shall not then granting the aid and educational institution discriminate against the any educational institution on the ground of that is under to management of the minority whether based on the religious or the languages. The compensation amount fixed by the state for the compulsory acquisition of any property of minority. The educational institution shall not restrict, abrogate, or their right to granted to them. This provision was added by the 44th Amendment Act of the 1978 to protect the rights of the minorities in this regard. Thus, the protection under the Article 30 is confined only the minorities, religious or the linguistic, and does not extend to any section of citizens such under the Article 29. However, the term minority has not been defined anywhere in this Constitution. Article 32 right to the constitutional remedies. The constitutional remedies refers to the legal mechanism provided by the Constitution of the country to safeguard the confers the fundamental right of the individual. First, right to move the Supreme Court for enforcement fundamental rights is granted. Second, the Parliament can empower the any other court to issue the direction other than the rights of the all kinds without the prejudicing of the some powers and the Supreme Court. And here the perhaps the any other court does not include the High Court because the Article 226 has already confirmed there the power on the High Court. This right makes the right to get the fundamental rights protected itself fundamental rights, thus making the fundamental rights real. It is a significance made under B.R. Ambedkar here this right to the heart of the soul of the Constitution. Writs. Types of writs purposes can be issued against, can't be issued against. Habeas corpus and direct and release of a person detained unlawfully. Uh, can't be issued against a public authority, b private individual. Can't be issued against lawful detention, b proceeding concern contempt of the court legislature, c detention outside the court of jurisdiction. Mandamus purpose the direct a public authority to do its duty can be issued against the public body, b corporation, c any inferior court, c tribunal, e government. The can't be issued against a private individual's body, b the discretionary duty, c the contractual obligation, d the president, governor, e CGI, CGI of the acting in judicial capacity. The quo warranto direct a person to the vacate on the office assumed the wrongfully only against the judicially select quasi-judicial authority, administrative, legislative, and the private body and individuals. The prohibition the prohibits a lower court and from the proceeding a cases a judicial, quasi-judicial, and administrative authority, legislative, and the private bodies and individuals. The accessories a higher court removes all proceedings from the lower court and the beginning of before itself. Only a statutory Constitutional public and offense. A. The ministerial offense. B. Private offense. Only the fundamental rights granted by the Constitution can be the enforced under the Article 32 and not any other right like non-fundamental. A writ of the prohibition is any order issued by the Supreme Court or High Court to the lower court prohibiting the constitution of the proceeding in the case. The condition laid down in the Constitution of the India for the issue of the writs quo warranto. A. The office must be the public and it must be the created by the state. B. The office must be the substantive one. There has been the contravention of the Constitution or institute in the appointing a such person to the office. Note: the Code of the Civil Procedure shall be under the concurrent list of the Constitution of India. A condition necessary for the issues of writs of the necessary in India. There, there should be a tribunal of in office having the legal authority to determine the question affecting the rights of the subject to then having duty of the act as judiciary. Second, the such tribunal or the office has acted as without jurisdiction. Article 33. The empower the parliament to restrict the abrogate and the fundamental right to the members of the armed force, paramilitary forces, police forces, intelligence against the analogous forces. The power to make the law under the Article 33 of the confirmed only the parliament and not a state. Legislature. Any such law made by the parliament can't be challenged in the court of the ground of the contravention of the any of the fundamental rights. Article 34. Sorry. Any rights fundamental. The member of the arm. The member of the armed force also cover the non-combatant employees of the armed forces such as the barbers, the carpenters, mechanics, cooks, chowkidars, booth makers and the toilers. Booth makers and toilers. Article 34. It provides for the restriction of the fundamental rights while as material martial law is a force in the any area within the treaty of the India. The expression of the martial law has not been defined anywhere in the constitution, but literally it means the military rule. The martial law is the imposed under the extraordinary circumstances like the war, invasion, and insurrection, and the rebellion right or the any violate the restriction of the law. Article 34 empower the parliament to the indemnify or the government the servant or any other person or the any act done by him the conjunction with the maintenance or the rest restoration of the other of the any area where the martial law has been the force. The act of the indemnity made by the parliament can't be challenged in the any court or the ground of the contravention of the any of the fundamental rights. Article 35. The law laws down that the power to make law to give the effective certain specific fundamental rights shall rest only in the parliament and not be a state legislature. The power of parliament only to make law. The prescribing residence as a condition for the certain employment or the appointment in a state, UTs and local or the other authorities. The empowering the court other than the Supreme Court or the High Court is to be issued the direction orders and the writs of the enforcement of the fundamental rights. The restriction or the abrogating the application of the fundamental rights to the member of the armed force, police or the force etc. The indemnifying the any government servant or the any other person of the any act done during the operation or the martial law is in any area. The parliament has the power to make the law prescribing the punishment for the offense such as the untouchability and the traffic in human beings for slavers. The Article 35 extended to the competence of the parliament to make law or the specified matter ever those matter which is may be fall within the sphere of the state legislature state list. Exception of the fundamental rights. Article 31A prohibits five the categories of the law from the being invalidated for the violation of Article 14 and the 19 and the reform the industry and the commerce and the include acquisition of the estate management of the properties, the amalgamation of the corporation, modification and the right to the director and the shareholders, the modification of the mining the issue that does not issue the state law in for the judicial review unless the reserved for the precedents the consideration of the any has received by his assent. For Article 31b, save as the act as a regulation including in the ninth schedule from the being the challenged. Article 31c as the insert by the 25th Amendment Act of the 1971. The contain the following to the provision or no law that seeks to be the implemented and socialistic directive principle as by the Article 29b or the C shall be the wide the grounds of the provincial fundamental rights in court by the article or the Article 29. National emergency and martial law concept borrowed from the German constitution. Second, it affects the only the fundamental rights but also center-state relation, distribution of the revenues and the legislative powers between the center and the state. It may be extend the tenure of the parliament. Third, the government and the ordinary law court and continue. The national emergency can be the imposed only on the three grounds: war, external aggression, and the armed rebellion. 5. It imposed the either in the entire country or in any part of it. 6. It has the specific detained the provision in the constitution. It is explicit. Martial law. The concept borrowed from the English common law. It affects only the fundamental rights and the government and ordinary law courts are suspended. The martial law is imposed in the region up to the backward of the law and order to due to the any reason. It is the imposed in the some specific area in the country. It has no specific provision in the constitution. It is impact. The present the position of the right of the property. 44th Amendment Act of the 1978 abolished the right to the property as a fundamental right by the prevailing and the Article 19(1)(f) and the Article 31 Article Part 3. The Act is instituted by the new Article 300A in the Part 12 under the handling heading the right to the property. It provides that the no person shall be the deprived is the property except in the authority of the law. And that this right is the property still the remains in the legal right and the constitutional right and through no the longer the fundamental right. It is not a part of the basic structure of the constitution. It is the legal right available the citizen only. The right is the property is a legal right is a distinct from the fundamental right has the following implication. It can be the regulated example the catalyzed, abridged or the modified without any constitutional amendment act by any ordinary law of the parliament. It protects the private property against the executive action but not against the legislative action. In case of the violation of the aggregation of the person can't be directly moved by the Supreme Court under Article 32. For its enforcement, it has more than the High Court under Article 226. The granted right to the compensation in case of acquisition of the property, private property by estate. The granted right the compensation case acquisition requisition of the private property by the state. There are two cases where the compensation has to be paid are when the state acquired the property of the minority educational institution Article 30 and when the state acquired and the land held by the person under the personal cultivation and the land is the within the statutory selling limits Article 31A. The first provision was added by the 44th Amendment Act and 1970 and while the second provision was added by the 17th Amendment Act 1964. Bharat Ratna Award. The award was instituted on the 2nd January 1954. Indian Council of the Ministers headed by the PM recommended the names of the President of India. C. Rajagopalachari, Radhakrishna and C.V. Raman were the first Indian. Mother Teresa was only the naturalized citizen received this. The Khan Abdul Ghaffar Khan and Nelson Mandela were only two foreigners to get the Bharat Ratna, plus the number of the Bharat Ratna awardees is restricted to the maximized three in other particular year. However, in 2024, this was the given five people. Padam Award. The award are the confirmed on the recommendation made by the Padam Award Committee, which is constituted by the Prime Minister every year. The nomination process is open in the public. Even the self-nomination can be the made plus all the person without restriction of the race, occupation, position, or the sex of the eligible by for the this award. However, the government servant, including those working within the PSU, except doctors and the scientists, are not eligible of this award. The total number of the award to be given in the year, including the postmortem award and the NRI, foreign and OCI, should not be the more than the 120. The Padam Award are the instituted in the year 1954 and are the announced every year on the Republic Day, suspended during the years 1978 and the 1979 and 1993 to 1997. Police custody. The immediate physical custody by the police of a person who has committed a crime. A person is arrested and brought to the public attention for the proceedings, and the suspected can be interrogated by the police. The judicial custody. It is the ascribed by the judge or the court of itself. This custody is ordered by the judge or the depending on the circumstances of the case. There is no interrogation done during the judicial custody unless the situation calls for the action and within the permission of the judges. Detention. The action of the detaining someone or the state of being detained in the official custody. Police only need the reasonable suspicious to the hold the suspects. The less serious, the may lead to the may lead an arrest in the form of the evidence found. It does not the shown in on the criminal record. Usually for the short period time, and then they have to be left go or the arrest. The seize someone by the legal authority and take them into the custody. Police need to hard evidence to the arrest someone more serious may lead to the jail then time it they convicted. That does so the up to the one criminal record can be the held in the until the bail is the post posted or until there the case come to the court. The custody, the merely the surveillance or the restriction on the movement of the person concerned, the holding a person in the custody for further inquiry and the investigation. More serious. There are the two types of the custody, police and the judicial, and depending on the circumstances upon the circumstance. It has the police record. The police custody is 15 days and the judicial custody is 60 to 90 days depend on upon the case. Home ground. Voluntary force first raised in India in December 1946. It assists the policies of controlling civil distribution and the communal rights. They are the raised under the Home Guards Act and rule and the state union territories. And they are the recruited from the amongst all the classes of the people and the walks of the like and given the raise the spare time to the organization for the betterment for the community. 6. Serve as the auxiliary force to the police maintains the internal security and the situation help the community in any kind of the emergency such as air raid, fire, cyclone, earthquake, uh, epidemic, help in the maintenance of essential service. Home guards. Finish fundamental rights. Thank you for watching.